Mr. Brannick, you're up.
Good morning, Your Honors. May it please the court, I'm Steve Brannick of Brannick, Humphreys & Berman here representing Blue Goose. If I may, I'd like to reserve 5 minutes of my time for rebuttal.
Sure.
This case is much simpler than it would first appear on first impression. It really comes down to a simple issue of contract construction. Our central point is that Cutrale breached the contract by terminating Blue Goose prematurely and without following the contract's change order and dispute resolution procedures. Just to give the court a little context, when the substantial completion date passed, which was November 1st, 2016, the parties were still settling on the final design of the project. In fact, the final drawings for Pond 1B weren't delivered until 4 months later in February of 2017. By then, it's obvious from the record that the parties are embroiled in a dispute over how much excavation was necessary and how much Blue Goose should be paid. Blue Goose was reluctant to proceed until Cutrale nailed down exactly what it wanted Blue Goose to build. As you recall, Blue Goose had earlier made some changes in the field without going through the formal contract change order procedures, and Cutrale refused to pay because they were not properly documented, and Blue Goose didn't want that to happen again. So now let's put aside exactly who was right and who was wrong in this long-running dispute between November and April. What is indisputable is that there was, in fact, a dispute, and the contract tells us the way forward in the event of a dispute. According to 7.3.1 of the contract, Cutrale was supposed to issue a construction change directive. That's a device that's used when the parties are in an impasse and they can't agree on a change order, which has to be done mutually. When a construction change directive is issued, everyone is protected. First, it tells the parties exactly what is going to be built and exactly what Cutrale proposes to pay for that. Blue Goose is then required to proceed, but it's protected from any claims of waiver. Blue Goose gets paid for its work in the meantime. And importantly, Cutrale gets the project finished. And then that dispute over how much is to be paid gets resolved later on in the contract to dispute resolution procedures and, if necessary, in litigation. But what did Cutrale do instead of issuing that construction change directive? It simply terminated Blue Goose. And we think that's what the breach of contract was in this case. Now, their response is going to be, well, they were in their rights to terminate Blue Goose because of the passage of the substantial completion date. And that's how the trial court excused Cutrale's breach. But that date was clearly waived. The November 1st date passes without any incident, without any mention. And it's obvious why, because the parties were still working on exactly what the final design was going to be. The first mention in a letter that the contract substantial completion date had passed wasn't until 4 months later in February, after all this back and forth between the parties. And even then, there was no threat of a default. The first formal default notice doesn't come until 6 months later in April, after the parties long back and forth over exactly how this project was going to go forward. But in the meantime, Blue Goose had continued to work on the project. Cutrale continued to commission work on the project, accepted that work, and until February paid for that work. The law is clear. You can't continue to ask for the work. You can't continue to pay for it. You can't continue to accept the benefits of that work. And then long after the completion date, argue that you're entitled to terminate because the completion date had passed. There are a couple of really good cases on this that we cited in our brief: the Horvitz case out of the 4th DCA, the RDP Royal Palm case out of the 11th Circuit, which cites Florida law. And this is consistent with a number of other cases that we cited in our brief that suggest that under exactly these circumstances, the substantial completion date has been waived.
Mr. Brannick, let me ask a question, because this case, it was not a summary judgment proceeding, it was a full trial. And it appears from my review of the record and the transcript, the positions being taken by the parties are diametrically opposed. There is some indication by one of your client's witnesses that they were requested to do extra work and he didn't really know anything about change orders and change directives. He just went ahead and was doing things. So it seems that, at least in the trial court's mind, the contract says how these things are supposed to proceed. The parties perhaps both failed to do things exactly in accordance with the provisions in the contract, but to some degree, isn't there a risk on your client's part to go forward without even the change directive being put in writing?
Or there would have been a huge risk to go forward. We would have been faced with exactly the same argument that they made when we asked for payment on the extra work that was done on Canal 1A.
But isn't that part of the problem? That in fact there were no directives. There was your client's position. Well, we were told what to do. We had a good enough relationship. We went ahead and did it. And the other side is saying they didn't do things the way they were supposed to. They could have gone ahead under the original contract. I think they recognized that would have created some problems, but ultimately doesn't so much of this case turn on credibility determinations by the trial court?
Except that that's not how the trial court resolved this case. The trial court issued, after this enormous record, a 5-page final judgment, and it doesn't resolve any of the factual disputes over who was at fault for why we got to where we were in April. It doesn't resolve who was responsible for the additional work that's going to require the work on Pond 1B to be changed. None of that was decided. All the trial judge did was decide very simplistically in 2 pages that Cutrale was entitled to terminate this contract. And the court made a finding in paragraph 6 of the final judgment. The parties' contract provided mechanisms for Blue Goose to seek an extension of time or costs, but no such requests were made. Paragraph 7, no change orders or construction change directives were executed. Paragraph 8, Blue Goose was still not complete with its contract work, not willing to perform in accordance with the contract. So I hear what you're saying, that there are not detailed factual findings, but there are findings. And so the question for our purpose of review is whether or not there's competent substantial evidence that supports these findings and legal conclusions, correct? That's correct. And so the trial judge decided that Cutrale was entitled to breach for 3 reasons. 1, because there was an anti-waiver provision in the contract. 2, because there was a time of the essence provision in the contract. And 3rd, because of what you just talked about in terms of whether a claim was made or not. We've talked a lot about in our briefs about that there's plenty of cases that say that time of the essence provisions can be waived and anti-waiver provisions can be waived. I think the cases are clear on that. In fact, the RDP case and the Horvitz case that I just talked about are both time of the essence cases. So we can put that aside. So now let's get to the heart of your question, Judge Silberman, which is the trial judge said that Blue Goose never made a claim. And that's just, that is not consistent with the record at all. If you look at what happened between August and April, clearly Blue Goose made a claim. There was pages and pages of back and forth where the parties staked out their position. And in staking out those positions, and I direct you specifically to the record at 2534 to 38 and 2585, Blue Goose sought additional compensation for its work, and it sought a construction change directive, and it provided an estimate for those claims. If you look at the contract at 15.1.1 doesn't say anything in particular about what a claim needs to look at. It just simply says that the party has to ask for additional compensation. It doesn't say it has to be put in a parchment with a seal on it. You just have to ask for it. And clearly Blue Goose asked for that. In fact, they conceded this. If you look at their May 2017 letter, this is in the record at R2776. This is the quote from that letter. This is the president of Cutrale talking. Blue Goose's, quote, representatives informed owner multiple times that the contractor would not proceed with the excavation of Pond 1B unless owner approved a change order, close quote. So it's clear that Blue Goose made this request. They conceded that Blue Goose made the request. So the question is, under this contract, what do you do if there is this intractable dispute between the parties? The trial court said they can just terminate, but that's wrong. They can't just terminate, not when the contract has been changed and when Blue Goose has been asking for this construction change directive. What the contract requires is that that because the parties could not agree on the way forward, that Cutrale was supposed to issue this construction change directive. As I said before, this would have protected everybody. Blue Goose would not have had to face a waiver claim. Cutrale would have gotten its project finished. Blue Goose would have been paid while the project was done. And if Blue Goose had refused to go forward in the face of this construction change directive, then Cutrale would clearly be in its rights to terminate at that point in time. Our big point is that the contract says very specifically how you cross the T's and dot the I's when the parties are in this sort of dispute. So don't get—
What is the remedy for Blue Goose if your position is correct and had the trial court agreed that demands had been made for construction change directives and Cutrale refused and failed to provide those? What options were there for your client apart from finishing the contract as executed?
If they had issued this construction change directive,
if Cutrale says, we want you to do extra work A, B, and C, and Blue Goose says, fine, put it in writing the way the contract says, and Cutrale refuses, what is Blue Goose left with at that point? Can it declare a default? Can it stop work? Can it continue work under the contract as already drafted?
I think that, that puts Blue Goose in a very difficult position. I think it would have all of those options, but then it would face an argument later on in litigation about whether it had waived its rights by not getting that construction change directive. And so
how does Blue Goose waive its rights if it asks for a construction change directive that documents what the owner is saying needs to be done, and the owner doesn't give it? I mean, I understand people can litigate over all sorts of issues, whether meritless or with merit, but is Blue Goose obligated to perform in accordance with a change that is never documented?
Blue Goose could go forward at that point in time, but it would have to place its eggs in the basket of hoping that it was going to succeed later on in not facing exactly the same argument that it faced before, which is that you waived it by not getting it.
Or could it say, look, either you want us to keep going with the original contract because you haven't given us any changes in writing, or do you want us to stop? We're going forward because you haven't told us to stop and you haven't given us any change. And that's one of their options, correct?
I think the contract is designed to prevent—
to
avoid putting the parties in that position.
But the contract is designed to prevent that. And the contract provides, basically, as many good contracts do, everything has to be done in writing. And you and I know, and the case law recognizes there are times that doesn't happen and there can be waivers, but that ultimately is a question of fact for the trial court, correct?
When you say that is a question of fact, I'm not sure exactly what you're—
whether the conduct—
no question of fact
the conduct that leads up to a legal determination of waiver involves questions of fact. Who said what, who did what, who failed to act, who did act. So those questions are factual questions that ultimately lead to a legal conclusion. Here, the trial court, at least arguably, according to Cutrale, made factual determinations against your client that led to the conclusion that your client didn't perform in accordance with the contract, and there was nothing amounting to waiver.
Well, I would respectfully disagree with that, Your Honor. I would have expected when I came into this case to have seen a 30-page final judgment where the trial judge, in fact, looks at these factual questions of waiver and resolves them. That's certainly how I would have drafted the proposed judgment if I had been on the other side. I was pleasantly surprised to see that the trial judge had not issued that kind of order in this case. In fact, it issued just this 5-page final judgment, of which only about 2 or 3 paragraphs relates to the waiver. And the trial judge didn't look at any of those credibility questions in deciding whether there had been a waiver here. The trial judge decided very simplistically. He said, first, there can't be any waiver because there's an anti-waiver clause. Well, this court's decision in the case that we cited in our briefs says that that's absolutely wrong. That can be waived. And then the trial judge said that this that there was a time of the essence clause, so it was impossible to waive. And again, the cases are just to the contrary of that. So the trial judge decided on a legal basis, and the trial judge was wrong on both of those legal bases. The only thing that comes close to a factual discussion is when the trial court said that Blue Goose didn't make a claim, but that's just not supported by competent substantial evidence. They concede that Blue Goose made a claim. In that letter that I cited at record 2776, they say that multiple times we asked for and said that the contract, we couldn't proceed unless a change order was provided. So there is no question that under the contract's very simple claim procedures, 15.1.1, that Blue Goose made this claim. So the trial judge is just wrong on all three of the bases, two of which are clearly legal, and one of which has some factual overtone in it, but the trial judge is just wrong because I think the trial judge was looking for, a piece of paper that had in capital letters on the top claim with some sort of seal on the bottom. Obviously, that's not what's required by the contract. So we think that the bases for the order, the way it was drafted, simply aren't legally supported. That's our point here. I think they would have a much stronger case if the trial judge had drafted this contract how you normally would have drafted the final judgment, how normally you would expect to see it, with a lot of bulletproofing on the facts. And maybe they didn't submit that sort of final judgment because they didn't think the trial judge would sign it. So they submitted this very simple the 5-page judgment that as I've discussed is just wrong.
Mr. Brannick, you're at your rebuttal time.
All right, then this is probably a good point for me to stop. I will reserve my remaining argument for rebuttal.
All right, Ms. Palmer.
Thank you. May it please the court. My name is Leanne Palmer and I represent Catrali Farms, Inc. May I reserve 3 minutes for rebuttal? I will first argue why the judgment should be affirmed, and I will secondly argue why the summary judgment should be reversed. What this case is about is burden and how for the last 7 years, Blue Goose has failed to meet theirs. They failed to meet it on the project, they failed to meet it at trial, and they failed to meet their burden today. What this case is not about, as Judge Silberman pointed out, is a relitigation of the facts, which is precisely what Blue Goose is trying to do. Blue Goose asserts no procedural errors nor interlocutory errors. Rather, it's unhappy with the result it got after 2.5 years of litigation, a 5-day trial on the merits, including 15 witnesses and all evidence stipulated to, as well as an hour-long hearing on its motion for rehearing that argued the same arguments you hear today. Appellant is asking this court to substitute its judgment for that of the trial court through reevaluation of the testimony, which this court cannot do. The final judgment should be affirmed for 2 reasons. First, Blue Goose failed to prove waiver. And second, Blue Goose failed to submit a claim and was not otherwise entitled to a change. Now, I want to jump to my second point first in an answer to Judge Silberman's question about what could Blue Goose do if it thought it was entitled to a construction change directive and Catrali didn't issue it. Blue Goose does have options under the contract. If you look at provision 15.2.1 of or Article 15.2.1 of the contract, it says if owner fails to respond to a claim that Blue Goose makes, then Blue Goose may file a demand for mediation. If the owner fails to respond within 21 days, Blue Goose can file a demand for mediation. From mediation, it can file a lawsuit. Blue Goose did not do these options. Its second choice was under provision 14.1.1, which does provide Blue Goose the right to terminate the work or terminate the contract if it's been stopped for 30 days or simply if it's been stopped for 30 days and after 7 days of written notice. Blue Goose did not do this either. So there are provisions in the contract that would have provided Blue Goose a remedy. But what's at issue here mainly is that Blue Goose waived these rights. Now, as Judge Silverman pointed out as well, the standard of review in this case is a mixed review because there are factual determinations and the trial court, the issues involved a mixed question of fact and law, as appellant has made evident by its extensive arguing of the diametrically opposed facts. This court has repeatedly held that when a trial to court's decision is based in part on factual findings, it presents this mixed question. Additionally, it does not matter that the final judgment contains all of the factual determinations of the trial court, because this court held it can be in First National Bank versus Boyd and in Gerard versus Gerard, that it can be inferred that the trial court considered a fact if there is competent substantial evidence in the record to support it. Blue Goose has not alleged until today that any fact is not supported by competent substantial evidence. Rather, Blue Goose presents these facts, these disputed facts, in the light most favorable to itself, as opposed to the prevailing party, which this court is required to do.
Ms. Palmer, let me ask one question as to waiver. Mr. Brannick contended that the trial court erred in its legal analysis as to waiver. In looking at the final judgment, it doesn't appear that the court specifically discussed waiver. The court made some findings as to who did what when and did or didn't ask for certain things, but the court didn't find or make findings specifically related to waiver. And what's puzzling to me is after the substantial completion date passed, it's clear everybody's still moving forward. So what do we make out of that fact that everybody kept working and the court doesn't specifically address the waiver argument?
I have 2 points to your question, because I think it is a two-part question. So as to your first point, the final judgment might not specifically have the word waiver in it, which was the substance of the motion for rehearing. And in that rehearing order, that's on page 5770 in the record, the court did say that Cutrale did not waive the provisions of the contract. Now, he didn't say that it was as a matter of law. He didn't say because of the anti-waiver provision. He said Cutrale did not waive those provisions. As to the second point,
Isn't that somewhat undermined by the factual pattern that's present in this case?
no, Your Honor, because there was not a continuation of work following the substantial completion date. What we have, if you look at the evidence in the record, you have Blue Goose failing to perform excavation on the reservoir. At that time, Blue Goose was demanding more money. If you look at
So what was the work that Blue Goose was performing after the substantial completion date?
After the substantial completion date, it was attempting to perform survey work that it was not of the reservoir, that it was not licensed to perform, because it had alleged that it had excavated more material than it had estimated internally, and therefore it would be entitled to more money. And so,
as I understand the testimony, their position was, and the testimony supported the idea that we were still doing work as requested by the owner. Did the trial court reject that?
yes, Your Honor, because the evidence was not there. The evidence supports that Cutrale did not request any new additional work pursuant to the contract. The only work that Cutrale requested was that Blue Goose complete the project. This court held in Williams versus Heritage Operating that alone, requesting that the breaching party perform the contract, is not a waiver of the termination provision. So in this situation, the evidence presented at trial was that Blue Goose was not requesting new work or under the contract. It was asking a completion of the contract. And secondly, the payments that were being made to Blue Goose on the reservoir project were for work that it did prior to the substantial completion date, but that it failed to submit invoices to until after the substantial completion date.
So it sounds like paragraph 16 of the final judgment is what you're hanging your hat on, where the court says Cottrell did not order Blue Goose to perform extra work.
Yes, Your Honor,
And that was a disputed issue of fact.
yes, Your Honor. The entire dispute, as this court has heard and has read in the briefs, is over the Pond 1 alleged redesign. But Pond 1B was not redesigned by Cottrell. Blue Goose is hanging its hat on an email from August 22nd, 2016 from Aaron Corkum to Scott Holmes. Now, Aaron Corkum testified at trial that that email was not a request for Pond 1B to be widened. That email was, hey, it was a reminder to Scott Holmes. You told me in April you were going to provide me water modification storage volume calculations for the 100-foot canal. And he had yet to do so. Blue Goose had not provided that. And so in that email, Aaron was testifying. Aaron said, I was asking for, where are those calculations? Notably, he also testified that not only did Scott Holmes not respond to that email to Aaron, he never communicated that this was going to prevent Blue Goose's ability to complete the project. If Blue Goose had communicated, hey, we think this is a redesign on that date, Cottrell could have easily clarified that issue. It wasn't until April of 2017, after Cottrell had put Blue Goose on notice, that for the first time, Scott Holmes referred to that letter or that email as a redesign. Scott Holmes's own letter from that opposing counsel had referenced from February 24th, 2017, in the record that he states, we recognize that when we widened Feeder Canal 1A, we knew that we weren't entitled to any additional costs on that project or on that excavation, because we understood that there would be a reduction in the size of Pond 1B. Even with the reduction of the size, however, on Pond 1B on that date, he continues. Blue Goose refuses to perform the work without additional money. Nowhere in that letter, though, will you find that a demand for a specific amount of money. What was really at issue, what stems from this monetary issue, really has to do with what kind of contract did the parties enter. That was the main issue, that this is a lump sum contract for $3.3 million. Blue Goose committed to excavating the ponds and the canals to a depth, certain widths and depths, to provide 2 days of freeze protection. Blue Goose position is that it's a cubic yard contract, a cost per cubic yard contract. And so that Blue Goose states it only had to excavate 734,000 cubic yards. But that appears nowhere in the record, or excuse me, that appears nowhere in the contract. And in fact, unit prices are specifically excluded from the contract. And so when Blue Goose was performing or was refusing to perform work on Pond 1B because it stated it will go over its internal estimates of cubic yardage, that is a breach of the contract, because it's not entitled to that additional money on that. There is no cubic yardage. It's not even in the plans, 734,000 cubic yards. That was an internal estimate used by Blue Goose and Blue Goose alone, and bid documents were expressly excluded from the contract. Because Blue Goose failed to prove waiver, and because it was Blue Goose's obligation to pursue a claim, they are the party that breached the contract, and the trial judge got correctly found so. Now, transitioning to the cross appeal, this court will note that it's almost the polar opposite of the main appeal in that it is a pure question of law, and the facts are not in dispute. However, as with the main appeal, Cutrale asks this court to apply the contract as written, giving purpose and effect to every provision of the contract, and to reverse the summary judgment on damages for two reasons. First, the contract only waives lost profit damages that are consequential. And second, Cutrale's lost profits were foreseeable recoverable damages. Pursuant to Article 15.1.6 of the contract, contractor and owner waive claims against each other for lost profits if they are consequential. The provision does not state that the parties waive lost profits, period, as Blue Goose argues. It is only those lost.
Ms. Palmer, one could read that provision that first the parties waive consequential damages, and then the following language defines what is a consequential damage, which includes lost profits.
Yes, Your Honor. In that case, it's consequential damages that are lost profits that are consequential damages are waived. That's not disputed by Cutrale. But what's at issue is that Cutrale's damages were not consequential, and the court decided this as a matter of law. The fourth DCA in HCA versus Cyberknife stated that as a matter of law, lost profits aren't always consequential damages, even where the contract waives such consequential damages. Therefore, the court stated, in the fourth DCA stated that the court has to consider the factual issue in determining whether the damages are general damages and foreseeable, or whether their lost profits are consequential and waived. Here, deciding it on summary judgment, the court decided as a matter of law that they are general or consequential damages, which the fourth DCA says it cannot do. Moreover, the rule in Florida is that the breaching party is liable for all damages which are reasonably foreseeable. This has been the law of this state since 1874, when the Florida Supreme Court in Brock expressly adopted the holding of Hadley v. Baxendale. And this has never been overturned. And in fact, this was affirmed by the fifth DCA in Scott. Now, taking it back to our 1L contract class, Hadley v. Baxendale states that the damages which the other party ought to receive in respect of such breach of contract should either be those that flow naturally from the breach or those that may reasonably be supposed to have been in the contemplation of the parties at the time they made the contract.
That holds true unless the contract provides language otherwise.
Yes, Your Honor, that holds true if the contract provides language otherwise. However, this contract does not state that all lost profits are waived, which it could have stated. Rather, it states that under the waiver of consequential damages provision, it states the parties waive consequential damages. And in that situation, it includes lost profits. The court has to read those provisions together to give each the purpose and effect. And therefore, this court should reverse the trial court summary judgment on damages.
Judge Northcutt.
You ended right at 17 minutes, Ms. Palmer, so you did a nice job. You have 3 minutes left for your rebuttal. Okay, Mr. Brannick, you're up.
I'll just start by spending just a second on the cross appeal. because the claim is decided by the plain language of the contract, which I think is exactly what Judge LaRose was alluding to. 15.1.6 provides that the contractor and the owner, quote, waive claims against each other for consequential damages, close quote. And then this is what's important. The contract then defines exactly what they mean by that. Quote, this mutual waiver includes damages for losses of use and profit, close quote. So all of the academic discussion about the definition of consequential damages in the case law is really irrelevant here. The contract decides the issue. Turning back to the merits of our appeal, most of what you heard was arguments about who was right and who was wrong in the underlying dispute that led to the redesign of Pond B, 1B. What's important is that none of that was resolved in the final judgment. Almost nothing of what she talked about appears in that final judgment at all. The only allusion that has been made to the final judgment at all, and this is the only allusion made to the final judgment in their brief, is where the trial judge said that Cutrale did not commission extra work. That's simply a matter of semantics. They had made the argument here that they didn't have to do a construction change directive because in their view, they were reducing the size of Pond 1B as opposed to increasing it. And the trial judge seemed to be accepting that. But as we discussed in our brief and as the case laws show, construction change directives apply to both increases and decreases in the scope. Now, no doubt the parties vigorously disagreed about what Pond B 1B was supposed to look like, but that dispute was supposed to be resolved by a construction change directive. There can't be any dispute that there was in fact a redesign. August 22nd, Corkum says, when are we going to be able to review the revised reservoir project? And then on August 29th, they request a proposal to add 9.2 million gallons of storage. And then in February, he says, please, this is Mr. Corkum again, please send revised drawing of Pond 1B. And then they have a meeting on February 3rd in which they talk about the redesign. And then on February 6th, there's an email where Corkum formally commissions the design change. And then on February 10th, Blue Goose gets the design change. There can't be any question that there was a design change here. The only dispute we have is a legal one over whether it matters whether this design change was a decrease in the scope or an increase in the scope of Pond 1B. Again, that's just simply semantics. The contract tells them what they were supposed to do. There was some talk about what Blue Goose's options were in the face of Cutrale's refusal to perform. Clearly, Blue Goose had some options, but those are just that, there's options. What this case is about is what is Cutrale's obligation here. Do they just get to terminate when we're involved in this dispute? And the answer to that is no, they don't get to just terminate. What the contract says is if you have this dispute, the answer to that dispute, Cutrale, is you issue a construction change directive, which then protects everyone. So whether or not Blue Goose had other options is irrelevant. The whole point of the contract was to prevent Blue Goose from having to make those difficult choices. So the simple question is, did Cutrale cross its T's and dot its I's before it terminated? Had it issued the construction change directive and had Blue Goose refused to proceed at that point, no doubt they could terminate. Our point is that they hadn't done what they needed to do in order to terminate. So the final point I'll make is that they say that the rehearing order decides the issue of waiver. That's just not true. The trial judge in the rehearing order says that they didn't waive, but then immediately says exactly why they didn't waive and makes the same arguments that I already talked about in my initial presentation, which was that time was of the essence, there was an anti-waiver, and that there had been no claim made by Blue Goose, a fact that we refuted in the brief and I refuted in the argument today. So for all those reasons, we believe that Cutrale breached the contract when it terminated it prematurely without issuing the construction change directive. So we believe that the final judgment should be reversed. And in any event, the trial judge's summary judgment was correct because it was based squarely on the language that the parties had agreed to in the contract.
Thank you, Mr. Brannick. Ms. Palmer?
Thank you, Your Honor. May it please the court. Blue Goose argues that the court should read the contract provision of 15.6.1 and apply it as written. As written, it states that there is a mutual waiver of consequential damages. That waiver then states consequential damages includes these lost profits. But that under that provision, it is a waiver of consequential damages. It is not a waiver of certain kind of damages. If it had said the parties waive these consequential damages and other damages, as case law has indicated, that could encompass lost profits, a complete waiver. But when the lost profits are read in conjunction with the consequential damages, there has to be a determination on the lost profits. It's not a ruling as a matter of law. For instance, as an example, the Western District of Arkansas held that in Mint Solar versus Sam's West, where an agreement excludes special, incidental, or consequential damages of any kind, including but not limited to lost profits, the court held that lost profits that were general damages could be recovered. There has to be this determination. What the cases that refer to Keystone Air Park and Hardwick versus Newborn do not apply the law of Florida. What they rely on is an Eastern District of New York case that is relying on New York's UCC provision. That is inapplicable. The Florida Supreme Court has held what law is what is the law in Florida. And as the 3rd, 4th, and 5th DCA have all held that lost profits can be general damages. So if the lost profit is a general damage, it is not waived by the consequential damages provision, and therefore summary judgment was error and should be reversed. And it is for all of these reasons that we request this court affirm the final judgment and reverse the summary judgment.
Thank you very much, Ms. Palmer. You guys are very experienced in all this, so you know that in order to leave our little virtual courtroom, you click the leave button in the corner of your Zoom screen, and then you'll be gone and we'll call the next case. Thank you both very much.